Okay. It's a prescribed time. I'd like to call the meeting to order. Today's meeting is being recorded, so would you make sure that you speak into your microphone and speak clearly, including me. We will have a roll call of officers
Losi,
here.
Winnis,
Here.
Jordime,
Here.
and Grindlin.
Here.
Can I have a motion to approve the agenda for this meeting? Is there a motion to approve?
I so move. Second.
All in favor, say aye.
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 Is there a motion to approve the minutes of the February 8th and continuation meeting minutes? Is there a,
This is Nancy. Move to approve.
Second.
all in favor, say aye.
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 Okay, we're about to begin a appeal hearing for Katie Rodacker Barch. And just one brief comment that we're going to make, what our responsibilities are. While the power of disciplinary action and/or discharge rests with the appointing authority, the role of Civil Service Commission in these hearing procedures is to ensure that such disciplinary actions are not motivated by political and/or otherwise improper considerations. I think we all have the format of the meeting, and so we'll start out with the opening statement by the employee or the employee's representative.
I'd like to thank the commission for their time today. I am here to appeal the City of Fargo and Fargo-Cass Public Health decision that I violated City of Fargo policies 400-8 and 400-8C, which in the exhibits and responses that were required to be submitted prior to the hearing indicate I did not violate said policies. They do, however, indicate that my employer violated those policies in what can only be inferred as discrimination of my disabilities and not only violating my rights as an employee, but also as a human.
Okay. Opening statement by the appointing authority and/or their representative.
Thank you, Commissioners, and I too thank you for your time and attention to these matters. Katie Rodacker Barch was not terminated for political or improper purpose, but rather terminated for cause. She was tested for the use of a controlled substance due to a reasonable suspicion, and that test was positive. In other words, she was under the influence of a controlled substance while at work. Whether or not she was impaired is irrelevant under the circumstances. The positive test result in the correctional health setting is disqualifying. Visible impairment is a basis for reasonable suspicion, but not the only basis. Further, measures for impairment are imperfect, such as field sobriety tests and blood levels, such that, again, impairment is not the only basis for a policy violation. The resulting positive test establishes a policy violation for the City of Fargo and the Cass County Jail, supporting the hiring authority's decision to terminate Ms. Barch's employment. Thank you.
Okay. Next is employee witnesses, if you have any. The employee
No,
acknowledge-
sir, I don't.
Okay, the employee acknowledges there are no witnesses. The appointing authority witnesses, if any.
I do, thank you. I would like to first, I will question 3 individuals today, just to kind of give the background and the flow of the information. So first, Tanner Coppin, and he is with Fargo-Cass Public Health, and I would ask him to step to the podium. I will do my best to direct questions to him with also making sure I'm speaking into the microphone, which has proven difficult in the past. Tanner, could you please state your full name for the record, please?
I'm Tanner Coppin.
And what is your position with Fargo Cass Public Health?
I am the Correctional Health Nursing Manager.
And how long have you held that position?
1 year and 4 months.
Do you supervise the correctional health LPNs?
Yes, I do.
Are the correctional health LPNs required to have an appropriate license from the Board of Nursing?
Yes.
And do you supervise then Ms. Barch?
Yes, I did.
Okay. Turning to the incident in question, on February 15th, were you made aware of jail personnel's concerns that Ms. Barch had possibly smoked marijuana during her shift on February 14th and possibly again on February 15th?
Yes.
Please explain how you were made aware of that fact.
Cass County Jail Operations Lieutenant Tommy Ray brought to my attention that it was reported to him by Cass County deputies had brought forward to him the concern that Katie had a strong odor of marijuana recently, using marijuana on more than one occasion. Deputy Claire Olson smelled it in the entryway and saw Katie exiting her car with a lit cigarette, which Deputy Olson thought it was odd that Katie would come out with a full cigarette and put it out almost immediately.
Had Deputy Olson passed through the entryway of the jail just prior to having this suspicion of use?
Correct.
Okay. Do you know if Deputy Olson thought there might be any other source of an odor in the entryway?
No.
Okay. Did Deputy Olson and others also enter the women's locker room on February 15th and detect a strong odor coming from Katie's locker?
Yes.
Okay. Would Deputy Olson and others in the jail have special training and knowledge regarding detection in the jail setting?
Yes, they would.
Okay. So what happened? So what happened next?
Lieutenant Tommy Ray reported to me that several deputies and other jail personnel had investigated the source of the strong odor of marijuana and patchouli oil known to Deputy Olson and others, and something often used to try to cover up the smell of marijuana was the oil, both following Katie into the building, but also coming from her locker on at least 2 occasions, with at least one person having noticed it in the locker room on several occasions previously.
When did this report come to you?
That was late in the day on February 15th, 2023.
What did you do then next?
I then contacted my supervisor, the Director of Nursing of Fargo Cass Public Health, Suzanne Schaefer, who advised me to contact Luke Lindberg, the City of Fargo Safety Director, to determine the appropriate course of action next.
Okay. Did Luke help you through the process to determine whether reasonable suspicion existed to undergo testing?
Yes.
Okay. So then what did you do next?
On February 16th, after conversation with Suzanne, Luke, and HR, I advised Katie that I would be taking her to Essentia Occupational Health for a drug test, and then we'd be taking her home pending the results. I told her that if she had any further questions about what was happening or the process, that she could call Luke, and at that time I provided her with the phone number if she would like to call Luke if she had any questions. She had several opportunities to call Luke and answer her questions while I was with her, but she did not do so in my presence. I told her that any questions would be best presented by Luke, as he has known the policies inside and out. After that, there was silence.
Okay. Did Luke confirm with you a policy violation by email?
Yes, he did.
Okay, what happened next?
Met internally and several times with jail personnel to determine a course of action. Jail initially determined it would undertake a independent investigation that was conveyed to Katie on March 3rd, and she continued on unpaid leave
Okay,
at that
thank you.
time.
I'm gonna pause for just a minute. Is there,
Yes, sorry for the interruption. Brian informed me that we're having technical issues with the live stream, and because of that, we've lost Nancy Jordheim. He said it'll take about 10 minutes to get everything rebooted. So I'm wondering if we want to take a 10-minute recess until those technical issues are resolved so that Nancy is also hearing. Thank you.
Okay. Our 10-minute recess is over. We'll continue on with the witness Tanner.
thank you. I understand that we were disconnected shortly after the report was made to Fargo Cass Public Health. And so I'd ask Tanner to just summarize what he did and the city did in response to that report.
Sure. So after the report, I then contacted my supervisor, the director of nursing, Suzanne, Luke Lindberg, the safety director, and had a discussion with them. And then Katie was, for reasonable suspicion, taken for a drug test and also given Luke Lindberg's contact information if she had any further questions with the process and how things worked. Then at a later time, there was notification by Luke to myself that there was a policy violation. After that time, we met internally, myself and jail administration, several times to determine a course of action. The jail initially determined that they'd undertake a independent investigation that was conveyed to Katie on March 3rd, and she continued on unpaid leave at that time.
Going back, do you recall when you were advised that there had been a policy violation? Was that on February 22nd?
Yes.
Okay, so there was a delay from the 16th test to the February 22nd. So the test was returned, do you know, February 21st? Is that correct?
Yes.
Okay. Do you know if the jail did undertake an investigation?
No, I do not believe that it did. The sheriff clarified that the use of marijuana in a positive test during work hours is a violation of policy, at which point Katie was terminated.
Okay. Did you ever talk to Ms. Barch or anyone else about the ability to use marijuana, participating in a medical marijuana program as a correctional health LPN?
No.
I have no further questions for Tanner. I don't know if any of the commissioners have questions, if that would be appropriate time now or after all of testimony.
Afterwards.
Okay. Thank you, Tanner. So I next have a few questions for Luke Lindberg, the HR safety manager. And Luke is seated to my right here, so we'll just sit here and go through those questions and responses. So Luke, if you could introduce yourself to the civil service members and identify your position and role.
Yep, Luke Lindberg, Safety Manager, City of Fargo, also the Drug and Alcohol Program Manager for the City of Fargo.
How long have you been with the city of Fargo?
10 years.
Okay, and has that been your primary role and responsibilities for those 10 years?
Yes, workplace safety and health, been the Drug and Alcohol Program Manager that entire time. Also oversee the federally regulated portions of our drug and alcohol program, so I'm considered the designated employer representative under those programs pursuant to US DOT regulations.
Okay, thank you. Have you been involved in determining reasonable suspicion for drug testing purposes in the past?
Yes. In addition to managing the program and developing the training for that specific piece, all the procedures for it, day to day, it's customary to get calls on fitness for duty questions from supervisors or department leaders related to a specific situation or a specific employee. It's quite common.
Okay, thank you. When did you first get involved in the employment matter regarding Katie Rodacker Birch?
I received a call on February 15th, about 4:30, 5 o'clock-ish from Tanner Coppin concerning a fitness for duty question regarding a jail staff member.
Okay. What did you advise as to next steps under the information you provided?
Yeah, I explained just the general process we would use to kind of move forward, gathering information to gain a consensus within public health's leadership team that we'd use potentially to execute a reasonable suspicion test. And advise we meet the next morning, the 16th, as a larger team to discuss if we had a reason to suspect drug or alcohol use.
And did you conclude that there was reasonable suspicion for purposes of determining whether drug testing was appropriate?
Yeah, the morning of the 16th, it became apparent that we had more than one law enforcement professional relaying information that we would consider a reason to suspect drug or alcohol use.
And what was that information?
Just the objective odor of marijuana, concerning behavior in terms of potentially hiding or masking use of marijuana or some sort of marijuana derivative. That was our primary reason to suspect use.
Okay. What did you advise as to next steps then?
I advise that we conduct a reasonable suspicion test using our vendor, Essentia Health.
And did you make those arrangements for Tanner to take Ms. Birch to Essentia Health for that testing?
Yes, I notified Essentia Health's occupational clinic the morning of the 16th, sent the service authorization form to the clinic so they were aware that she was coming in. Just a normal customary process there.
Okay. Did you advise Tanner to provide your direct contact information to Ms. Birch for any questions or concerns?
Yes, as the designated representative, at that point when a test is conducted, the results only come to me in an effort to, maintain the privacy of the employee and keep drug testing information out of the workplace as much as practical. I always ask that the supervisor give the employee my card or my number so they can contact me directly.
Okay. Did Ms. Birch contact you at that time?
At that time, no. The first time I spoke with Katie was on the 24th of February.
Had the medical review officer or MRO reached out to you in the interim to attempt to contact Katie or Ms. Birch?
I received an email from Essentia Health on the 20th that the MRO was looking to make contact with Katie.
And did you provide additional contact information to the MRO?
I reached out to Tanner and the rest of the public health team to obtain additional contact information, ask them to reach out to Katie as well to contact the MRO.
Okay. Do you know if the MRO eventually did reach out and connect with Ms. Birch?
My records show that happened on the 21st of February.
Okay. And is that the day that you received the test results from Essentia Health?
Yes. I first received them on the 21st.
Okay. Did you have what day did you say you had a conversation with Ms. Birch? Was that before or after the final results?
After the results, after I received the results on the 21st, we had a couple of different meetings, and then on the 24th was the first time I talked with Katie.
Okay.
That was via phone.
Okay. Did Ms. Birch advise you of any status regarding a prescription marijuana registry with Minnesota?
Yeah, during our conversation on the 24th, she relayed that she was having trouble getting access to either her email or her account with the state of Minnesota, and that her card had expired in December.
Okay. Did you advise her to work with the MRO to ensure the validity of the results?
Yeah, I talked specifically at that time about just the process and how medical information related to the test is really the purview of the MRO and not the employer.
Okay. And at that time, you do not discuss medical conditions or treatment, is that correct?
Correct.
Okay. What happens next then?
So after that conversation, the test results remained unchanged by the MRO from the 21st of February.
What does test result remain unchanged mean? What would happen if it was changed?
Well, it means that Katie tested positive for marijuana on February 16th while at work during her shift as a correctional health LPN. If it were to have been changed, it would have been noted on the test form.
Okay. What happened then? So you had a positive test. I'm going to go back for one question that I think is maybe for clarification purposes. At the time of the testing on February 16th, was Ms. Barch placed on unpaid leave?
Yes,
Okay, and so she continued on an unpaid leave status?
correct.
Okay, if that test result had come back negative or able to return to work, what would have happened then?
She would have been returned to work, and then that time off would be changed to paid regular hours
So she would have been compensated for the time that she was on unpaid leave?
with a negative test, yes.
Okay, thank you. Did you then engage in several discussions with the jail personnel and others regarding policy violations and Ms. Barch's ability to return to work?
Yes, additionally, there was a discussion of an independent investigation, but ultimately determined that a policy violation had occurred and would not be admitted back to work in that facility.
Okay, so what happened next then?
There was a meeting on March 3rd where that information, well, there was a meeting and that we were still waiting kind of for that final word from the facility operator as far as if she could return or not.
Okay, and when you received that final word, then what happened?
On March 28th, there was a scheduled meeting to advise Katie that her employment was terminated immediately.
Okay. Have you ever discussed with Ms. Barch about obtaining a prescription for medical marijuana in Minnesota and the impact it might have on her employment in the jail setting in North Dakota?
No.
Do you know anything more than what has been presented with Ms. Barch's statement regarding her prescription for use of medical marijuana in Minnesota?
I know that specifically in Minnesota, when applying for authorization to purchase, a user or a person seeking authorization would be signing off that they're aware that it's not for use in a correctional facility amongst other locations and job assignments or industries where that specific drug is still federally illegal.
Thank you. I have no further questions of Luke at this time. And the final person I'd like to question is Desi Fleming, sitting to my left. And I will just ask Desi to introduce herself and give a little background for you also.
Good afternoon. I'm Desi Fleming, the Director of Public Health. My role is to oversee the operations at the Health Department as well as assure policy adherence for the City of Fargo as well as Fargo Cass Public Health. I have been with the Health Department for 31 years.
So we have a little unusual situation here. that Fargo Cass Public Health has a contract that provides services, nursing services to the Cass County Jail. Can you tell us a little bit about that contract relationship?
Sure. We have a contractual agreement with Cass County to provide nursing services on site at the jail. So when we advertise, we specifically hire someone for that environment. During the interview process, everyone is made aware that they are following not only City of Fargo policies, but also the Cass County policies. So they must, the work environment is covered by Cass County, employment policies are City of Fargo. And both of these entities have a drug-free policies in place.
Okay, thank you. Were you made aware of a reasonable suspicion that Ms. Rodacker Barch may have used or been under the influence of marijuana while employed at the correctional facility?
Yes, I was made aware by our Director of Nursing, Suzanne Schaefer, after working hours on February 15th. We then met as a group on February 16th with the HR team, with our city attorney, and talked through that reasonable suspicion process, and then later determined to take the employee for a drug test.
Okay. Were you advised that there had been a policy violation upon return of the drug test analysis?
Yes, I was out of the office from February 21st to the 24th, but Suzanne Schaefer, our Director of Nursing, was notified on the 22nd of the violation of the city's drug and alcohol policy, and then she subsequently notified me.
Okay, thank you. Were you engaged in communications with the Cass County Jail regarding the circumstances that presented themselves with that policy violation?
Yeah, we have in our contract situations, either with the county, we also have contracts with the schools district. Again, the employees have to follow both sets of those policies so that that contracting agency has the authority to deny an employee from continuing to provide service for due cause. So in this particular case, we had a lot of correspondence with the county and jail administration to talk through the policy violation and potential steps forward. On March 25th, we did receive an email from Sheriff Johnner with a definitive decision that Ms. Barch would not be allowed to return to the Cass County Jail for employment.
So once that determination was made and the City of Fargo policy and the Cass County policy prohibited return to work, what happened then?
Well, based on the facts that we had reasonable suspicion reports. We had a positive drug test with no qualifications from the medical review officer, that this was a violation of the City of Fargo and the Cass County drug-free workplace policies.
Okay, thank you. Did you determine that a positive test result was a reportable event to the Board of Nursing?
We did. After reviewing confirmation of the policy violation, again with no qualification from the medical review officer, we again consulted with our HR team, with the city attorney. And at that time, based on the information we had, and we determined that as an employer of professional nursing services, that the appropriate action was to report to the Board of Nursing for a policy violation so that they could determine any necessary actions going forward.
Thank you. Do you know what the status of the report to the Board of Nursing is?
Our last follow-up call was on March 29th, and I believe they were taking that under consideration this week. They did say any final determination they would send me via email, and I have not seen anything as of this time.
Okay. So, to your knowledge, what is the status of Ms. Barch's license with North Dakota?
I'm not aware that any action has been taken. On the Board of Nursing site, it has a notation that says, please contact the Board of Nursing for further information. It does not have any change of status at this time.
Okay, thank you. Has Katie ever talked to you or anyone else to your knowledge, excuse me, Ms. Barch, about her ability to participate in a medical marijuana program in Minnesota with her employment at the correctional facility?
No, not that I'm aware of. With our Fargo Cass Public Health, any controlled substance that's a prescribed medication to be used while working would need to go through our employee health program for the approval process. Supervisors would need to be involved if there were work accommodations that were needed, and then I would be consulted for any agency implications. And to my knowledge, none of those have happened in this case.
Okay, thank you. So you made the determination to separate from employment with Ms. Barch based on the policy violations of the City of Fargo and Cass County, is that correct?
That is correct.
Okay, is it still your decision, following the review of Ms. Barch's statement and our discussions, that that is the proper action and was with cause for violation?
Yes.
Thank you. I have no further questions or witnesses. Thank you.
Okay. Then we'll proceed to Commissioners' questions of employee and employee witnesses. Do any of you have any questions? Nancy?
No, I do not.
Mike?
Do you believe that the reason for termination then is due to the City of Fargo's policies? The drug-free policy, that is the reason for termination? Nancy?
Yes, I do
Not
believe
you,
that.
not you, Nancy.
Oh, gotcha.
That question was directed at me, I assume, right? Yes, again, it was not only our policy violation of the drug-free policy, but also Cass County's.
Right. On March 3rd, there was a letter written from Suzanne Schaefer to Ms. Barch saying that your continued employment with the City of Fargo is contingent on a determination from the Cass County Jail following their investigation.
So in those contractual relationships, again, people are hired for that specific position. And so if they make a determination that an employee is no longer able to fulfill their employment with them due to just cause, they will say or have said in the past that an employee cannot return for employment. And when that happens, we have no further job opening for that individual.
So a nurse in a different capacity would have been treated differently?
I think it kind of depends on circumstances. Sometimes I think with the Cass County Jail, and they have a little bit higher level of policy that they face given the environment. Within our Fargo Cass, we may have more latitude at times for working through some situations, but in these contract situations, it really is dependent on that entity that we have the position for.
Out of curiosity, is a positive test for medical marijuana a violation in and of itself?
I can go ahead and answer that. Yep. So the shortest answer is yes. I think with a qualification on a positive test result, things could be different. And that also affects, and that difference is also related to where that specific employee is working. I think we have many workers that marijuana would be an automatic disqualifier.
So if I can just ask the clarification question, this positive test was not qualified because there wasn't presentation of the existing medical marijuana card. Is that correct?
Right. The medical review officer, which is a board-certified doctor specifically trained to review drug test results, certified that it's a positive test without qualification.
Mr. Chair,
Yes.
I have a question. Desi or Nancy, would the policy at Cass County, would their drug and alcohol policy, which I understand Ms. Barch was also subject to, is that correct? The policy at Cass County, would that be considered a zero tolerance policy? Since she was told that she would no longer have that job there based upon, it wasn't their test, but it was your test. She was immediately disqualified. Is that a zero tolerance on Cass County's part?
I
know?
think in this instance, it probably is. Even like in the statute, or even if it was a medicinal use, they don't allow that on correctional facilities. So to me, that speaks to a zero tolerance policy.
If their policy read like yours, like the city of Fargo's, consequence of a test result, a positive test result, if it's the first positive test incident and the employee participates in an assessment and rehab, they can get their job back or they can continue to work for the city of Fargo. If Cass County's read that way and they said that she could go through, because it was her first violation, she could go through the rehab part of it, would the city have terminated her then? Or would she?
I think this is difficult, just because with the not knowing if there was, we know we have a positive test, it's really difficult to prove impairment levels. And so anytime with a professional nursing position, when you're caring for other people and you're responsible for higher level things, I think that does make us pause to think that we may have to limit those situations going forward. Certainly, our referral process and working with EAP does work with employees to get them back. I'm not really sure if this would be an appropriate rehab going forward.
And I just want to call to your attention that the letter from Sheriff Johnner dated March 24th, that Ms. Barch would no longer be allowed on the property in her professional capacity. So that too has an impact on the city of Fargo's employment of Ms. Barch.
So the consequences section of the city's policy is, it doesn't seem to differentiate between different employment classes. Is it, that it applies to all first-time offenses? Is that right, Jill? I know maybe I should be asking you that, or Luke. Yeah.
Sure, I'd be happy to address, and Luke may fill in as well here. But so yes, the policy does allow for that first offense for there to be a formal referral under our drug and alcohol program. However, that referral, again, assumes that we have a position for that individual. So I think that's where, each case can be a little different. And as Desi has described, that's what, in part, is what is different in this situation, because at the time that we confirmed there was a policy violation, we did not know entirely what the consequence would be in the decision from Cass County Jail Administration. And so when we enact that referral, the continued employment is also contingent upon that referral. So we needed to first determine and understand, is there an opportunity for continued employment under the circumstances? If so, then the referral would have been implemented. But that was a significant factor in the decision-making. So there can be different circumstances, and yes, policy does allow for that referral, but we have to look at the full picture of the time that decision is being made.
So it's fair to say, or accurate to say, that her employment with the city was terminated because there wasn't a job for her any longer, really? It's not necessarily a positive drug test?
Correct. There was no job for her as a result of the policy violation and the determination by Cass County Jail Administration.
And this is Nancy on the phone. And the other piece here, the significant piece, is that position is actually covered twice, correct? Both by the city of Fargo and by the jail service employment through the health department. You've got that employee has two sets of regulations, as it were, or agreements.
Yes, that's correct.
Uh-huh.
I have a question, excuse me. I have a question for Nancy. The city has a contract with Cass County Jail to provide services. Does Ms. Barch have a contract with the jail or with the city for that position? Or is there's only one contract? It's the city's responsibility to provide a person.
That is correct. There is no contract of employment with Ms. Barch. She was hired for the correctional health LPN. That's the position she applied for, knowing that that work would be at the jail.
Okay, this is for Desi. Apparently, Ms. Barch has worked for the Public Health Service prior to applying for the job at the Cass County Jail. She was an employee. And so when she applied for the job and accepted the job, that must have left an opening in your department. Is that correct?
Yes, and that has been subsequently filled.
Okay. And I see that, and you say there was no position for her to return to back with the Public Health Service or the Cass County Health Service. And there was no position for her to come back to?
We have no open LPN positions.
I see in the paper part of form that there's an ad all the time for a public health nurse. There's no position available?
So we have registered nurse positions open right now.
Okay.
That's a higher level.
So she could not go back to her regular job. I'm having a problem with the contract between the city and the county and whether the county regulations come into play. I know they have control of their facilities, but basically we're going back to our policy 400-008, and that's the disciplinary action that I think should have been applied only and without consideration. But if you say there was no job for her to come back to, I guess it's true. So.
So, Mr. Chair, I'm still a little confused about what Katie's position is. Will she have some time now to go through the events as she sees them? I think, she hasn't said too much about, that what the violation is in her mind, why she was terminated. Is she going to have a chance to go through some of this now? Or is it at the end of the final statement?
We have no other questions for the employee and or the authority. We'd like to have a.
I think Ms. Barch is a witness for herself.
What? Yes, well, that's the
And
next
when-
statement, that's final statement by the employee. Do you have a statement? Or do you have any questions for Ms. Barch?
No, I just have one more question, and maybe this doesn't pertain, or whether or not you have the knowledge of this, but a person goes to Essentia Health and they test positive, and in the materials, I see that there was 2 positives and one was immediately qualified. The second, there was potentially a qualification in process, but it was a timing issue. If that qualification had come into play, would that 3-day response that you would have received from Essentia Health been negative?
I can answer that. Specifically, what we've been told by the MRO is that in the situation you described, we would be issued a report that would still have the positive result for the one substance, but it would have MRO's notes that would then certify the existence of a fact within that test timeframe, if that kind of makes sense.
It does.
Yep.
It does.
I have a question for, well, I guess for Luke or for Tanner. Somebody said, has said that that certificate had expired in December. I think Tanner mentioned that. Is that true, that that exemption had expired? Because we have a copy of a new exemption. Had that,
I can answer that question, yeah. So my notes show that during the call with Ms. Barch on the 24th, that she relayed that to me as she was discussing the difficulty of getting in to obtain the documentation from the state of Minnesota. So that is in my notes, that's what she told me.
that certificate had expired in December.
Yes. Now, the new certificate that was presented to us, our understanding under Minnesota state law is that's valid for 1 year from the date of issuance.
Okay, yeah, okay, I see the expiration date on the certificate, so, so it's a 1-year certificate, thank you.
So, okay, I'm gonna try one more question. Maybe this is for you, Luke. If Katie would have talked to the MRO between the 21st and the 24th and said, I have the certificate for medical marijuana use, that would have been the evidence that the MRO would have used to possibly give this test a qualification or to overturn the positive result?
Yeah, I don't believe that in this, for the specific substance we're talking about, that it would have overturned that, but it would have come to us with notes from the MRO.
So
So,
it would have been a positive result, but the MRO would have noted that Katie
yes,
has a certificate for medical marijuana use, which the city was not aware of. I'm
No.
taking it up until this incident happened.
no, we were not aware. And maybe to simplify it even more, the role of the medical review officer in the testing scenario is to establish the fact for us.
Okay.
If I can just add to that, we don't know if the medical review officer retroactively looks at it looks like it was not in effect at the time of the testing potentially as well. And then also making note that it's a prescription in Minnesota and she was employed in North Dakota. And so it's not really an apples for apples, so to speak. If you've got a license in Minnesota, that's where your license applies. So I think there is the distinction there, but I think in any event, it's a positive test result.
Right. I mean, there are just so many questions here with, medical marijuana that we don't know. I don't know anyway. And so even if you had this certificate, would you be allowed to smoke marijuana on your break during work hours? Do you have in any policy, is there that much detail?
Well, I can address that it's not actually in policy, but it is in North Dakota state law that you cannot have any marijuana on correctional facility grounds. And also that, and that is, let me see if I can find it here. North Dakota Century Code 19-24.1-33, under limitations, it specifically says that This chapter does not authorize a person to engage in and does not prevent the imposition of any civil liability or criminal liability or any other penalties for engaging in the following conduct. And it includes possessing or consuming usable marijuana on the grounds of a correctional facility, as specifically stated in North Dakota law as a violation. And also under North Dakota Century Code 19-24.1-34, the use of medical marijuana does not prohibit an employer from disciplining an employee for possessing or consuming usable marijuana in the workplace or for working well under the influence of marijuana. So North Dakota law does address those issues there.
Okay. I have no further questions.
Are there any further questions from the commission?
But that statute probably wouldn't relate to reasonable suspicion. You know, there was no possession, there was no tested impairment.
Well, as I indicated earlier, the reasonable suspicion was the odor that had been detected on numerous occasions in several locations. So that reasonable suspicion was a basis for the testing. Impairment, what I'm finding is there really is no perfect measure for impairment. Sobriety tests and blood alcohol testing, there isn't a number that we know is resulting in impairment, so impairment alone is not the only factor to consider in employment.
This is Nancy. I'm also understanding that having this on the property is a violation of North Dakota. Is that correct?
Can you repeat that?
That is correct, and we, that was part of the discussion with the Cass County Jail on independent investigation, whether or not it was actually on property. We did not ever determine that it was on property. There is suspicion that it was in her vehicle, but we have not confirmed that basis for that suspicion.
Okay. I also, just to make note, I also noted in the, I've got to tell you which page I'm on, in Katie's report, that she indicates that her use of cannabis is on off hours. And if that were true, then this odor would also not be prevalent. It would be in her system, but not prevalent. Am I understanding that correctly?
Again, I can say that the reasonable suspicion was the strong odor, but where it was used is not been confirmed.
Mm-hmm. Mm-hmm. Thank you.
I have just one statement. I'm confused with what we're supposed to educate this thing on. Is it policy 400-008? Is that our concern as a city employee? And that's the only policy that we should be considering in our roles. I don't know who can answer that question. It's a broad question, but.
Well, and I appreciate the question because it is confusing with the Cass County policies being in play here also. But I really do think it is the totality of the circumstances that you are looking at to determine whether or not the decision of the appointing authority was politically motivated or for improper considerations. And so I would just call your attention to that standard of review of the appointing authorities' decision-making under the circumstances.
Then I have one more question for Desi. Apparently, Katie has worked for the health service for 4 years before she took the jail job. Is there any other reports in her file of disciplinary action that are open to the public? Or any other job evaluations that are in her file?
I believe there was some just performance improvement plans in her file. There was nothing related to drug use.
Are there any other questions for the commission? Then we'll proceed to the final statement by the employee.
I'd first like to clarify that my medical marijuana card was never expired. My driver's license at the time expires on your birthday, which for me is Christmas Eve. And in order for them to give me access to my account to get the qualifying document, I needed to send them an unexpired copy of my new driver's license. My medical marijuana card renews in February of every year. And that I did not use or have marijuana on me while at the Cass County Jail, or while I was employed, or during working hours, or before working hours. Let's say that I fried onions and garlic and chicken in my kitchen while my coat is on a chair in the kitchen. The next day, my coat smells like fried food. Would that indicate that I was frying food on my break in my car at work? If I had that same food smell and that smell of onions and garlic on me, in my hair, or my scrubs, on my breath, or on my person in general, then maybe there'd be a slight possibility I was frying food in my car on break. But there wasn't a single report of any odor detected on my person at all, nor detected on my person during the day of that drug test. It should also be noted that the medication in question is legal without a prescription in the state where I live. It can be bought at most gas stations and all vape shops around the state of Minnesota. I, however, because of my licensure, have a medical reason, and make sure because of my licensure, to have a medical certification, because I do have a medical condition and authorization to use marijuana. It does not affect my work, as I don't use the medication at work. I use it outside of work hours, and there has never been a report of otherwise. It should be noted that a urine drug screen will show a positive result up to 4 weeks after consumption is stopped of this medication, and it does not indicate current impairment. I have shown how I have followed and attempted to follow the aforementioned policies, but was blocked from being allowed to do so by not being allowed the 3 business days to provide proof of my prescription to qualify my results as negative. In policy 400-8 C on page 9, number 16, it says within 3 working days after receiving notice of a positive test result on a confirmatory drug test, an employee or job applicant may submit information to the medical review officer, which may explain that positive drug test result. And as per the call logs that I submitted, I made sure to call her the next day when I had that information available to me. And I was not allowed to give her that information. I have also shown how that same policies were not followed by my employer, along with multiple ways in which it was violated. These violations effectively released my medical information to multiple people and agencies that had no right to know about it. My medical information being represented and then weaponized against me, used to end my employment, and now has forced me to have an open discussion regarding something that's confidential between myself and my provider in a public setting. It's not only unjust, it's mortifying. Why would it be okay that I am on one doctor-prescribed narcotic, but it's not okay for the other? And the one that I take at work is the one that they're willing to accept as okay. The one that I don't take at work, somehow there's a problem. Why are my disabilities and the treatment being discriminated against, but one isn't? Why am I being held to a policy that my employer is not having to adhere to?
We'll have a final statement by the appointing authority.
Again, this is a very unfortunate situation. Any employee that has a prescribed controlled substance needs to go through our employee health program for that approval process. In this situation, we had reasonable suspicion reports with a subsequent positive drug test, which is a violation of our drug-free workplace policy. We also have a contractual agreement with Cass County for employment, which also adheres to drug-free workplace policy, even at a higher level, given the nature of the jail environment. Given these circumstances, termination for cause was the justifiable action for this case.
Thank you. I'll open the floor for discussion amongst the commission, I would guess.
Well, Mr. Chair, I guess unfortunately for, Katie, marijuana is federally is not a legal drug and is going to be on that testing list. So, I think that's one of the unfortunate circumstances, with the federal government compared to a local jurisdiction or state that allows marijuana to be used medically. They're still never going to pass a federally mandated drug test for marijuana. I do work with this at my regular job as well, and that's going to be a positive. I don't know that there's anything, even if you would have disclosed to public health that you had this card and you went through the process, I don't know how, and I don't think it can be proven that would erase a positive drug test. We just don't, I don't know that we know that, and I don't know how that's possible. It's not been possible at my place of work, so I think that's just, you're caught up in an unfortunate circumstance in that way. Unless there's something, I don't know about public health, that if they knew about her medical marijuana, that would some way impress upon MRO to change a test result. I just don't see it.
Nancy, do you have anything to discuss?
I'm with Paul here. Hang on, can you hear me?
Yes.
Yeah. I'm with Paul. I think this is not, in my opinion at least, a disability issue in that it was not disclosed to either employer, the city of Fargo or the Cass County Jail, who was the actual employer at that time, which, again, from my HR experience as well, is critical to that piece. So we're not talking about impairment. We're talking about reasonable suspicion, which is unfortunate, and I get the argument about garlic, but nevertheless, that is certainly a very distinct odor that comes with that particular use. But we are talking about somebody had suspicion. They went through all the proper processes. The proper process said that, yes, there was marijuana present, and there was no previous notification that would have allowed either Katie to stay in her first job or, and therefore not be hired in this job, or to stay in this one. It's ugly, but I'm really, I'm feeling like Paul. She's caught in a tough spot.
Mike, you have any discussion? Really, there's no more discussion. I would entertain a motion.
I would move that we uphold the city's recommendation.
Is there a second to that motion?
I'll make a second to that motion.
Okay. Can we have roll call votes?
Losi,
No.
Wennis,
Yes.
Jordheim,
Yes.
Grinlin.
Yes.
That should conclude. Would the secretary record the vote? The motion is carried. The appointing authority is upheld. We shall go on to other business, and I would, on our agenda is nominations of chair and vice chair. Considering there is an opening now, and there will be, could be one fairly shortly, I would rather postpone these, the nomination of the chair and vice chair until a meeting in May. And I would also like to postpone the reading of the new employee policy 300-008 until that meeting in May. Is there any other business?
Again, this is Nancy.
Yeah.
I would, whether I'm serving you may or not, I would like to suggest that we do review for potential clarification of those situations where we have double employment, basically, which is what this was. Any kinds of things that might, and I just, and maybe it's not a policy, maybe it's simply part of a procedural piece that gets handed out to folks, so that there's real clear clarification that you are under two different, similar but not always exact sets of procedures.
Yeah, I agree. This is a rather confusing situation where you have an employee that's contracted out to somebody else and who rules and regulations we're supposed to go by. So I would ask Jill to try to clarify these policies, and at our May meeting, we will discuss that clarification also.
Yeah, yeah.
Is there any other business before the commission? Sensing none, the meeting is adjourned.